Hello, everybody. Long time no talk. I have been spending time with a family and doing Christmas festivities. So, Merry Christmas, Happy Holidays. We got to catch up on the Jay-Z thing. And y'all, I don't know where on earth Alex Spiro gets the time. I don't know where he gets the energy, but the man has been filing like he don't have no Christmas, no Hanukkah, no nothing to celebrate the last couple the last couple weeks. I'm not joking. Like, I don't know where he finds the time. Like, look at his roster. Not only is he representing Jay-Z, alone a full-time job. Not only is he representing Elon Musk in some type of securities situation against the government. Not only is he representing Meg Thee Stallion. Not only is he representing Eric Adams, the New York City mayor, who's dealing with his own indictment in this same district. Now, this is criminal, right? Like the Eric Adams one is criminal. The man is busy. Really, he's definitely going to make a mark on the legal world and on the pop culture world, one way or the other. But unfortunately for Alex Spiro, the judge just yesterday, Thursday, December 26th, the day after Christmas, gave Alex Spiro a Christmas present that he will never forget. And I think that these little catty little letter motions are going to come to a screeching halt, if I had to guess. Let me show you what I mean. Now, the most recent document that we covered, I believe, extensively, is this one right here, this letter motion. Okay. Now, this letter motion was docket number 46. Let me just pull that up so that I can reacquaint y'all. It's been a while since we talked about these cases by going over, each page of the filings. So let me pull up that 46 just to remind y'all what it looked like. Because like I said, again, Alex Spiro has definitely been filing a lot of these things. And the judge did kind of, in my opinion, admonish him yesterday over it. Okay, so here's 46. Again, yesterday the judge filed number 53. So we have seen a few things being filed publicly since the last time we talked about this. Again, like I said, it's been the holidays. I haven't been able to stay on top of things like that. Okay, so this 46 was one of the several letters that Alex Spiro wrote in, kind of telling the judge about this NBC interview that the Jane Doe did do with Chloe Malos, a CIA Mockingbird shill, if you ask me. I don't know. I don't have a test to run or anything. This is just my opinion, which last time I checked in 2024, we're allowed to have. I don't know how much longer we're going to be able to have opinions, but right now I think we're still allowed to have them. So it's my opinion that she's a Mockingbird shill. But yeah, so this was the 46. This was 46. I believe this is the last or maybe one of the very last things that we did talk about in this Jane Doe versus Diddy and Jay-Z lawsuit. Remember, she went on CNN with, in my opinion, CIA Mockingbird shill Chloe Malos, and now they're holding that interview against her. Remember, Alex Spiro was saying her story, the Jane Doe story, has absolutely no factual basis at all whatsoever. And his basis for that extreme statement was that the Jane Doe had some inconsistencies in her story, that Chloe Malos decided for the first time in her career ever that she knew how to vet a story all of a sudden. Yeah, that whole thing. Okay, so then the next document that was filed was document number 47, of course. This one was only 2 pages long. This one was also filed by Jay-Z and his attorney. And this one is just the proposed order to show cause. And this is simply Jay-Z and Alex Spiro asking the judge to order Buzbee not to destroy any evidence, which I believe is already a rule. I don't really think he needed like an extra preservation of evidence order, but maybe. Then the next document you have after that is document number 48, which is a memorandum of law in support of an order to show cause, which has still to do with the preservation order. So let me pull that up. Now, the purpose of me showing y'all this is just so that I've mentioned each document. We're not going over line by line all of this stuff. This would be a several hour long video, but I just want to bring to your attention so we're caught up since I took a Christmas holiday break and all of that. So here is document number 48. And this is, like I said, the memorandum of law in support of the judge. They want the judge to order not only this Jane Doe to preserve evidence, but Alex Spiro and Jay-Z wanted the judge, and still want, I'm sure, the judge to strike the whole complaint against Jay-Z. The reasons, pretty much, I'm paraphrasing here, But these are all public documents, and I'm basing my opinion upon these documents, which are federally filed public documents. Let me actually update my little scroller. Okay, so nothing in this video that I am saying should be considered as a fact or an expert opinion. These are just my opinions as a lay person. I am not licensed to practice law. I gave my license to practice law up. The purpose of this video is to comment and provide opinion on matters of public concern. Do not play with me. Okay, so Alex Spiro and his client Jay-Z, they want the judge to completely strike this. They want the judge to do it like the other day. They do not even want to deal with this at all whatsoever. So they're not only asking the judge to order the other side preserve all this evidence, they're also asking the judge to strike the whole complaint to get rid of it. They're doing this on a few different bases. One of these bases that Alex Spiro purports to use is that Buzbee is doing things unethical. He's violating his ethical rules. Alex Spiro also says that Buzbee did not properly vet this case, which, to be fair, Buzbee kind of seems to confirm. He says that he relied on a previous law firm to vet these claims, instead of, independently vetting them himself. I don't know. I mean, also there's really good reasons on the other side to explain why she might have inconsistencies in her story. Like, it's been a long time. She was only 13 when it happened. She says she has PTSD. Now, a lot of people are saying she has autism, so that means she's not going to have a good memory. As someone who's autistic, I'm going to just go ahead and say no. I'm not going to be parroting. Y'all think I have worse memory than the general population? No. Just because you have autism doesn't mean your memory is worse. And I actually take personal offense to the commentary channels who have come out here and said that. Who have come out here and said, well, she's autistic. She ain't going to remember. What? No. But there are real reasons, which I would say do make sense. Like, she was young, like it was 25 years ago, like she might have been on substances, like the fact that if even a little bit of what she said happened to her that night is true, of course there would be trauma. And I do know that sometimes the dissociation trauma phenomenon does result in people forgetting, memory lapses. Like, you don't even store the memory. So, all that makes sense. But she can't remember nothing because she's autistic. Y'all, please. Say you never met an autistic or something in your life. I mean, come on, y'all, please. And I'm trying hard not to also, kind of just like perpetuate the same type of stereotype by saying, like, if anything, autistic people, aka people like me, have a better memory than the common average everyday person. I ain't going to say that. I ain't going to go so far as to say that, but I would be more likely to believe her memory would be better because she is autistic than worse. But I'm not going to go that far. Okay, so of course, people have gone over this document. It's 19 pages long. Again, this is document number 48. We're just going through just so that I have touched on every document in order for the Jane Doe suing Diddy and Jay-Z lawsuit. So again, this is a motion to strike, a motion to preserve evidence. This is a memo. A memo is something that you write in support of a motion. It's kind of all your legal reasons and stuff like that. So that's what this is, a memo. And it's in support of a few things: motion to show cause, motion for an order from the judge ordering Buzbee and Jane Doe to preserve evidence, and I think most powerfully, a motion to strike the complaint. So this, again, is filed by Alex Spiro on the behalf of Jay-Z. And it's just more of kind of the same. It's more of Alex Spiro talking about how, in his opinion, it's just outrageous, unbelievable, and preposterous that this Jane Doe could have inconsistencies in her story. He calls her story obviously false from the start. He says that her complaint is impossible based on her own admissions. He re-brings up that Benji Madden. And then on page 1 and going into page 2, Alex Spiro in document 48 then drags J-Lo. Alex Spiro drags J-Lo by the clip-ins into this lawsuit. Nobody was mentioning J-Lo in this lawsuit publicly until Alex Spiro, and listen to what I'm saying, in this lawsuit. Now, this led to some speculation, which then resulted in some fake news about me, which I had to correct, and which I will certainly be enjoining any media outlet which parroted that fake narrative. Y'all could go watch my most recent video if you're interested in that. Actually, my most recent live and my most recent video. But anyway, in the filings, we have not seen J-Lo mentioned until document 48, and that was filed by Alex Spiro. I find it very interesting. That no media outlets are blaming Alex Spiro for doing this dragging of Jennifer Lopez into the lawsuit about her clip-ins. Nobody's giving him credit for it. Nobody's blaming him for it, even though clear as day, he sure did do that. Now, there is a blacked out and redacted celebrity B whose identity still has not been revealed. And it's my opinion and belief. Alex Spiro did this on purpose. That's my opinion. He put Jennifer Lopez in this lawsuit on purpose to make people speculate that it was Celebrity B. Now, could it be Celebrity B? Yep. Could it be that he accidentally disclosed Celebrity B by putting J-Lo's name in here? Yep. Could it be that he intentionally disclosed who Celebrity B is by putting J-Lo in here? Yep. But could it also be, listen up, before y'all file a lawsuit, make sure you put this part in because I'm going to make sure the judge reads it. Could it be that Celebrity B is somebody else, perhaps even somebody, I don't know, I'm just naming names, like maybe Beyonce, maybe Aaliyah, maybe, I don't know, some other female celebrity that perhaps Alex Spiro wants to take the heat off of. And so therefore he's putting in J-Lo to make it seem like J-Lo's Celebrity B. Yep, all these things are possible. And then things I didn't even mention are also possible. Okay. But what I can tell you beyond a shadow of a doubt is the way that J-Lo, Miss Jennifer Lopez, got dragged into this lawsuit in the filings by name, openly and not redacted. Alex Spiro. Not BJ Investigates, not an inmate suing Diddy, and not That Surprise Witness. Alex Spiro, whatever in the hell, however you say. That's who dragged J-Lo into this lawsuit. This is where it happened, document 48. All right. So again, he's citing that NBC article and he's just saying it got to be, struck. 49 is a declaration of Alex Spiro. And I'm definitely not getting into this one too much, but I just want to show it to y'all. This one is for the purposes of supporting Jay-Z's emergency motion for an order to show cause. So that document we just read, the memo, this is just Alex Spiro's own statements in support of that. And they're basically just dragging Buzbee. They're saying, he's crooked. He's getting sued by all these clients. A lot of people were reading the lawsuits. I have the lawsuits. I'm not going over them because I'm feeling like this is starting to get a little bit too attenuated and a little bit too circus. I'm trying to zone my focus back in on 2 or 3 major lawsuits and just keep reading the filings because it is fun to talk about so-and-so did an interview and so-and-so did, this or that. And I do want to talk about that, but I am not getting into all these lawsuits filed against Anthony Buzbee. I will be making a video about them, but only to give some opinions on how I think they're similar, how I think they're different. And it's really not that urgent, to be honest. It really is not. It does seem to be orchestrated. I'm not the biggest Buzbee fan. I have some criticisms of him, and I also have some criticisms of his intake procedure. I did try to contact Buzbee myself to give him some evidence that I have, not on Diddy, but on Lou Taylor, because I assume Lou Taylor, the business manager, will somehow come up either through TriStar or Robin. Robin Greenhill from TriStar Sports and Entertainment was named in the Lil Rod suit. So I tried to reach out to Buzbee. It was very strange, the intake situation, and I'm not really trying to get too involved in all of this, so I'm not going to be saying too many details right now, but I'm not the biggest fan of Buzbee either, so don't take my seeming defense of him as I've chosen a side, because I haven't. I do think that Buzbee is just as willing to use these type of tactics as anybody else, as Alex Spiro and Akinfilo and the rest of them. So I'm certainly not the Buzbee fan in the world, okay? But it looks to me, based on the just sheerly on the timing of the filing of all these lawsuits against Buzbee, they all happen basically within a month. Like 4 or 5 lawsuits all get filed, including, when I say lawsuits, I mean also like a complaint on his license or whatever. Like all this stuff gets filed within a month. And it's like none of these people had any problems. They had nothing to say until Buzbee sued Jay-Z pretty much. And so if anything, to me, in my opinion, the fact that Buzbee's getting sued all these times is actually more proof, in my opinion, and to me as a member of the public, that Jay-Z and Alex and Quinn Emanuel and whoever else, Marcy Kraft or whatever her name is, and the rest are actually retaliating against Buzbee for filing these lawsuits. I mean, in my opinion, again, I don't know. I wasn't there. So then we move on to document 51. And in document 51, we do have Jay-Z opposing the Jane Doe continuing to proceed anonymously. So the judge has already decided one time to allow the plaintiff to proceed anonymously. Now, when the judge decided this, she decided that before Jay-Z was ever named. So when the complaint was updated or amended to include Jay-Z as celebrity A, Jay-Z pretty much immediately, through his attorney, Alex Spiro, filed to release this woman's name, the Jane Doe. Okay, now that she's suing 2 high-profile individuals, her name should be released. So this right here, this is just a 3-page, kind of like really only like a page and a half if you just look at where it's actually written. Alex Spiro is just reiterating that Jay-Z should get to see who this plaintiff is and who's suing him. Also, he should be able to publicly investigate her and all of that. So he's just arguing that Jane Doe shouldn't be Jane Doe. She's done these interviews. She sued these high-profile individuals. And so for that reason, she should not be able to hide behind the anonymity of being a Jane Doe. All right, so then we're going to move on to document number 52, which is the second to last document. And again, another declaration of Alex Spiro. He is just filing and filing and filing. Okay, so this one was filed on the 23rd, the day before Christmas Eve. And again, he's just, I don't really see even what he adds new here. It's just like he's adding the same arguments over again. Look, again, he already filed such a declaration. Look, on the 18th, he filed a declaration in support of his motion to strike and in support of the motion to show cause to get rid of the lawsuit, basically. And then he files another declaration 4 days later in support of the anonymity thing. But he doesn't add, in my opinion, doesn't appear that he adds too much new information, because it looks like all he does is just attach the stuff he already done said. But it ends up being like 40 pages long. That's a 40-page document, because he wanted to put 1 page, 1.1 pages, and then exhibit 1 is his documents we just looked over. Whatever. It's just, I could understand if I'm the judge, I could understand her getting a little overwhelmed with all this. Like, can we get to a hearing before you keep giving me the same 40 pages worth of crap I already just read 5 minutes ago? And basically, I feel like that's kind of what she said. She snapped. So the moment you've been really waiting for, let's get to that filing. It's 5 pages long, and it's really, the judge just really goes right on off. She goes right off. She snapped. In my opinion, I would too. All right. Document number 53, order. And it is a multi-pronged order. And she also gives some admonishments and some warnings to Jay-Z and Alex Spiro. Okay, here it is right here. And this was filed just yesterday. She didn't waste no time, this judge. This was filed the day after Christmas, December 26th. And let's just do a brief reading. Plaintiff Jane Doe filed this action October 20th, alleging violation of the Gender Motivated Violence Protection Act. By order dated November 6th, so like almost 2 months ago, the court provisionally granted plaintiff's motion to proceed anonymously, so to proceed as a Jane Doe, explaining that defendants had yet to appear in this matter, meaning like Diddy and the Does 1 through 10 inclusive, as well as all these businesses, had not appeared yet. And so for that reason, the balance of interests weighing for or against allowing this Jane Doe to keep being a Jane Doe may shift as her suit continues. So we talked about this in my previous videos, and in the video that I did about this one, is like the judge said, yeah, you can be Jane Doe for now, but it all comes down to this balancing test, right? Like imagine it's a scale. I got to get me a scale. I've been looking for a nice vintage one to hold up and like put stuff on. But you know, the scales of justice, right? Like on one side, you're weighing the interests and the benefits of the plaintiff, the person suing. But on the other side, you're weighing other interests, like the interests of us, the public, and the interests of Jay-Z, the defendant, and the interests of Diddy, another defendant. And so regardless of whether y'all are very sympathetic to those interests, the point remains that people are supposed to be presumed innocent until proven guilty and presumed not liable until proven liable. And so there's the balancing test all the time in the law. But in this particular one, the judge has, you know, kind of like, I in my mind, I see it as marbles. So it's like putting marble on the scale for each factor. On the one side, there's all these marbles for the plaintiff's interests. And then on the other side, there's all these marbles for everybody else's interests, right? And so as the case goes on, more marbles are going to fall on each side of this, you know, hypothetical scale, which is going to tip the balance. And at some point in my belief, I predict the balance is going to be tipped such that we're going to be allowed to find out who this Jane Doe is. And this will probably be closer to if it looks like it may go to trial. That is just my prediction. I really do not know. We are going to have to see how it all plays out. But my opinion is based on this filing that we are looking at, and we are going to read through it together so you will be able to see why I have this opinion, and you are free to reach a separate, different, similar, or completely opposite opinion. So then the judge goes on and says, on December 8th, so about 20 days ago, plaintiff amended her complaint to add Jay-Z, and she again reiterated her request to keep going as a Jane Doe anonymously. The judge says, but this time, Carter's counsel, that's Alex Spiro, appeared and moved to deny the Jane Doe's motion, and in the alternative, to dismiss her amended complaint pursuant to Federal Rule of Civil Procedure 12B1. Jay-Z also moved for an expedited hearing. Remember, he wanted the hearing expedited, and he wanted to shorten the time for somebody to reply to something in one day. I mean, he was really asking for all kind of stuff. The next day, the judge says, Jay-Z's attorney filed a letter containing a declaration from some random associate at his law firm. Remember, we read that law firm associate, I don't remember her name, but she was talking about how she had talked to somebody who was a Buzbee client, and Buzbee didn't really do a good job. And so she talked to her and all that. Remember that? And it was like a transcription of the voice call or a notes of it. That was at docket number 42. So if y'all are interested in that, you should go back and watch my video at docket 42. The judge says Spiro filed this letter containing this declaration from basically an employee, like one of his employees, one of Spiro's employees at the law firm, recounting a phone conversation she had with an unnamed woman. Again, the judge is like, okay, so some random anonymous person, you're not even going to tell me who it is. This random woman claiming that Buzbee had encouraged her to lie about her experience of SA. Spiro asked the court, and again, that's Jay-Z's lawyer, to consider this additional information in connection with plaintiff's motion to proceed anonymously. Buzbee denied Jay-Z's allegations. So that was December 8th. Okay, December 13th, Spiro files another letter alerting the court to a recently published interview of plaintiff with Chloe Mayloss on NBC News. This was docket number 46. And also it's saying C number 52. 52 is the one we just read. Remember I showed y'all he's going on with it again? In the interview, plaintiff, that's the Jane Doe, speaking anonymously to Chloe Mayloss, explained her allegations against Diddy and Jay-Z and her reasons for coming forward now. This is docket number 46. Again, the judge is citing Spiro. Spiro is citing NBC, but the judge is citing Spiro. She's saying, you said yourself, the plaintiff remained anonymous. Spiro. Jay-Z's lawyer, Spiro, points to that interview in which Jane Doe admitted to inconsistencies in her story as evidence that Jane Doe's claims have, quote, no factual basis whatsoever. Spiro also argues that Buzbee violated a certain federal rule of civil procedure, that's 11B, by, quote, failing to undertake a reasonable inquiry into the facts before filing the complaint. Spiro also takes issue with Buzbee's supposed, quote, failing to seek admission pro hoc vice to the court, and requested an expedited briefing schedule for a motion to strike the first amended complaint. Okay. The next day, Spiro submitted yet another filing, December 14th, a motion for an emergency order directing the preservation of evidence and striking the amended complaint. Okay, so the judge is like, that's all the things that this man was doing. Like, I don't have any time to do anything over here. Like, I ain't got nothing else going on but to read from Alex Spiro's letters all day. So now the judge is like, let's get to these issues, I guess, since y'all are trying to rush me over here. Number one, she says, Let's address this motion to proceed anonymously. So does Jane Doe get to be Jane Doe? As of right now, okay? This is not a permanent ruling, and the judge is very clear about that fact. The judge says, in deciding whether a plaintiff may proceed anonymously, courts balance, quote, the plaintiff's interest in anonymity. So remember, one side of the scale is the plaintiff's interest. That's Jane Doe. Okay, and when you're weighing something against something, that means on the other side of the scale. So the plaintiff's interest in anonymity, so the plaintiff's interest in being a Jane Doe versus being her name, has to be balanced on the other side of the scale with, quote, both the public interest, that's us, and any prejudice to the defendant. So any prejudice that Diddy and Jay-Z would face. Now, I already hear y'all, already read your comments in my mind, I already see it. Who cares if they're prejudiced? They don't care about being prejudiced. Blah, blah, blah. I understand the sentiment. Truly, I do. I understand the sentiment, and I understand to some of y'all, Jay-Z and Diddy, they did it for sure. Okay. But in a court of law, that is not how it works, and it cannot be how it works. We have to make sure we go through all the evidence. We have to make sure everything is fair. We have to make sure, because we've seen things can get said that ain't true. And what I mean by that is we have two sides that are saying diametrically opposed things, which means somebody is not telling the full true story. Maybe not even on purpose, maybe on accident. I'm not even saying, oh, they lying on purpose, but somebody's not telling the full true story because the two sides already in this case, before discovery really even starts, are diametrically opposed. The judge says the Second Circuit, so the circuit, has laid out a non-exhaustive list of factors that a judge has to consider when deciding whether to let somebody be a Jane Doe or forcing them to come out and publicly tell their name. The factors, I'm not going to get into too much of an analysis. I'm just going to read them off real fast. Number one is whether the lawsuit involves matters of highly sensitive nature or personal nature. Number two, whether identification poses a risk of retaliation, physical harm, mental harm to the party seeking to be the Jane Doe, whether identification presents other harms, whether the plaintiff is particularly vulnerable, whether the suit is challenging the actions of the government or that of private parties. Okay, so that's going to come to matter whether the defendant is prejudiced, whether like that would be Diddy or Jay-Z are prejudiced by allowing this plaintiff to be a Jane Doe, and whether the nature of that prejudice differs at any particular stage in the litigation. Okay, so this right here, all these things that we're looking at right here, this list 1 through, I believe it's 10 factors, these have already been decided. Okay, sealed plaintiff versus sealed defendant in 2008. This is a precedent. This is a case law. This is already something the judge has to look at. This judge cannot just decide to not look at these things. It's a rule and has been going on almost 20 years, right? Since 2008. The other factors are whether the plaintiff's identity has already been exposed or whether her identity has been confidential or his or their or whatever. You know, this plaintiff in this case is a Jane Doe, a woman, but these are factors that the judge would have to consider no matter who the plaintiff was. Number 8 is whether the public's interest, that's us, in the litigation is furthered by requiring the plaintiff to disclose her identity. Number 9, whether this is a factor the judge has to consider in her decision to allow the plaintiff to move forward anonymously at this stage of the litigation. Number 9 is whether, because of the purely legal nature of the issues presented or otherwise, there's an atypically weak public interest in knowing the parties' identities. And number 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. The judge says the court is not required to list each of the factors for use in any particular formulation as long as it is clear that the court balanced the interests at stake in reaching its conclusion. So the judge is kind of saying, I believe what the judge is saying here with this paragraph is that she's going to say later, see how I have these highlighted 1, 2, and 7? She is going to rely heavily on 1, 2, and 7, but she's also probably relying on other factors. She's probably considering all of them, but she's saying because of 1, 2, and 7 specifically, that's really going to tip the balance right now for me in the favor of the Jane Doe to let her still keep being a Jane Doe. But she's also saying, I ain't required to tell y'all everything I weighed. Okay. So I'm going to tell you some of them, but this isn't necessarily all of them. Okay. I don't have time to go through all that. I don't want to spend 25 pages over here. I believe that's what's going on. She says here, the weight of the factors tips in favor of allowing the Jane Doe to remain anonymous. Oh, of 1, 2, 4, and 7. So I said 1, 2, and 7, but it's actually 1, 2, 4, and 7 that the judge relies on. You see those highlighted ones I have? Oh, let me make this bigger. See, these are highlighted 1, 2, 4, and 7. The judge says factors 1, 2, 4, and 7 weigh strongly in the favor of allowing her to continue being a Jane Doe. In her amended complaint, Jane Doe alleges that defendants rug and ard her when she was only 13. Courts in this district have recognized that allegations concerning SA are, quote, highly sensitive and of an extremely personal nature. Plaintiff is particularly vulnerable to the possible harms of disclosure. According to her amended complaint, she continues to experience depression, PTSD, and a seizure disorder associated with the stress of the SA. Moreover, Buzbee, which is this Jane Doe's lawyer, asserts that many of his clients who have filed similar lawsuits against Diddy, so we're not even talking about Jay-Z right now, we're talking about Diddy, claim to have been threatened by Diddy for their decision to speak out. Now, this is an interesting little legal sort of, I don't know, conundrum, because it kind of looks like Jay-Z is being punished for Diddy's alleged behavior, because it's Jay-Z and Alex Spiro who have filed to make this Jane Doe come out and use her name. But the judge is saying Buzbee said Diddy is threatening people. So no, Jay-Z, because Diddy is threatening people, you don't get to have your request for the anonymity to be lifted granted. The judge says, finally, although plaintiff did sit for an interview with NBC, NBC allowed her to conduct this interview anonymously. So take it up with NBC. They should have said who it was. But the judge isn't just knocking it out of the park for this plaintiff. She kind of implies that this was a close call. She said, granted, several factors. Remember those 10 factors? She got 4 of them weighing strongly in favor of the Jane Doe. That was 1, 2, 4, and 7. Yeah. She says, but there's some stuff weighing in favor of Jay-Z and Diddy, don't get me wrong, and there's some stuff weighing in the favor of the public, which has a right to this information. So she says, granted, several factors weigh against allowing this plaintiff to go forward as a Jane Doe. There's a lot of factors, in other words, that make the judge think that this should not be an anonymous plaintiff. Plaintiff is challenging the actions of private parties, not the government. Okay, so but private parties. So you would think, that's number 5, you would think that because the action is against private parties, that the public has a little bit less of an interest in knowing who the Jane Doe is. The judge says, however, quote, given the media attention surrounding the case, the public has a substantial interest in this litigation, separate and apart from its general interest in an accused, quote, being able to publicly confront an accuser. So the judge has really given us a big 1-2 punch that's going to probably, and this is one of the reasons I base my opinion that this Jane Doe is going to eventually be disclosed, but just not right now. This particular sentence is one of the strong indications to me that might end up happening. It's because, look, the judge says, all right, well, Jane Doe should probably be able to be a Jane Doe if we're only looking at factor 5, because on its face, she is suing private parties. She's not suing the government. The judge goes on to say, but there's a lot of media attention surrounding this case. And so, quote, the public has a substantial interest in this litigation. And that's completely separate and apart from the other interest that I, as the judge, have to consider, she's saying, which is Jay-Z and Diddy do have the right to publicly confront their accuser. So a lot of these things are weighing in the favor of having to put Jane Doe's identity out there. So at the beginning of this video, I said Jay-Z and Spiro did get issued an admonishment, I believe, and a warning. This kind of looks like a warning too, but to Buzbee and Jane Doe. Not like ominous, not in a bad way, but just kind of like, hint, hint, y'all. If you keep this going, there's going to eventually come a time where I'm not going to be able to keep the public out of knowing who this is, specifically given the media attention surrounding this case, which both Alex Spiro and Tony Buzbee have now availed themselves to. I also want to point here a clue. I don't even want to say a clue no more, because they're trying to twist these freaking clues as if I'm like not a clue, like Blue's Clues, a children's show. They're putting that shit in headlines like I have some type of proprietary secret knowledge of something. It's just so annoying. I'm very annoyed at the fake news that's come in the last week. The judge says alternative mechanisms, right? This is, I think, is number 10. So then the judge does address the final issue, alternative mechanisms existing to protect the confidentiality of the plaintiff. And the judge says, namely, the redaction and sealing of certain documents. The judge says, most importantly, what does the judge think is the most important factor that's weighing in the favor of Jay-Z and Diddy and any future defendants which may be added to this case? She says, most importantly, Jane Doe's continued anonymity, so her continuation of going by Jane Doe instead of her name, quote, may cause prejudice to defendants. That includes Sean P. Diddy, Puff Daddy Combs, and Jay-Z. Quote, making it more difficult for them to collect the facts necessary to mount a defense and, as appropriate, to challenge plaintiff's credibility. Combs, identifying the most significant form of prejudice to the defendants, okay, and then they're citing a Combs case. Now, I don't know if this is Sean P. Diddy, Puff Daddy Combs or some different Combs case, but this I wanted to point out because see this part right here I have highlighted in pink, the substantial interest. This is a ruling, okay? Let me put it in a box. This is a ruling, and this is my prediction, my psychic vision. I'm going to stop calling it a clue. I'm going to stop calling them clues because you see how these fake tabloids like to use my words and twist them. I'm going to start calling it a psychic vision from the mothership. The psychic vision download from the mothership is this right here is going to end up being relied upon in future Diddy litigation because it's in the Southern District of New York that now a judge has literally ordered, quote, the public has a substantial interest in this litigation. Now, the judge is kind of saying, look, listen, I got some things to say to Alex. I got some things to say to him over his behavior and over all these letters, but that doesn't mean that I don't see where he's coming from on some of this stuff. The judge is saying, I don't take it lightly that there is definitely some prejudice that's going to ensue by allowing this Jane Doe to continue being Jane Doe. The judge says the court does not take such prejudice lightly. I don't take it lightly, Spiro. Calm down. I don't take it lightly, Agnifilo. Calm down. The judge says at this exceedingly early stage in the case, the factors counseling against disclosure on the one side of the scale for Jane Doe, those are still outweighing exposing who is Jane Doe at this early stage. The judge says, accordingly, Jane Doe's motion to proceed anonymously is granted. So I'm going to let her keep being Jane Doe for now. But the judge issues Jane Doe, in my opinion, what appears to be a warning. Plaintiff Jane Doe is advised that because the balance, the scale, the marbles, quote, will certainly shift. Certainly, the judge said, certainly, you can be certain that we're going to end up putting enough marbles on either side where it's going to look, the balance of these factors will certainly, not may possibly, not could probably, may likely, no, could likely, no, will certainly shift. The judge said, Jane Doe, you're on notice, girl. Right now, I'm on your side. But, quote, because the balance of these factors will certainly shift as the case proceeds, the judge says, especially if and when the parties engage in discovery in earnest. The court intends to revisit this decision at a future date. So the judge is kind of, I feel, in my opinion, sneaking in another little dig at kind of both sides, but really I think Alex Spiro, Jay-Z's attorney, by saying we haven't even started discovery, quote, in earnest. It's kind of like just for play at this point. So how about let's get to that stage first, buddy? Okay. So long story short, 50 minutes into recording, the judge finally gets to the issue of whether Jane Doe can keep being Jane Doe. Long story short, yep, she can, but only for now. And the judge predicts that the balance test will certainly shift as the case proceeds, specifically once it gets to the stage of earnest discovery. And so for now, yes, Jane Doe can be Jane Doe. No, we're not going to reveal her identity. We will get back to this at a later date, the judge says. Now, number 2, the remaining motions. And this is where she really lays in to Alex, in my opinion. She says, since Carter's attorney, aka Alex Spiro, first appeared in this case 17 days ago. So she's really pointing out it really hasn't been that long at all. Like, stuff in federal court just takes time, which Alex Spiro, a Harvard graduate, someone who's been practicing law for a long time at a very prestigious firm, professional, I mean, is like a white shoe firm. I mean, it's very, very, it's in the top 10, I believe, in the world of law firms. Okay. So he just got here 17 days ago in this case. So he should know, as somebody that is, this is what I, this is my opinion right now, what I'm saying. He should know, as somebody who is well-versed in federal cases and high-profile litigation, that this stuff just takes time, okay? So the judge is like, okay, so 17 days ago, Alex Spiro comes on the scene. Quote, he has submitted a litany of letters and motions attempting to impugn the character of plaintiff's lawyer, attorney Tony Buzbee. Quote, many of them expounding on the purported urgency of this case. So the judge cites to docket number 38, paragraph 1 and 2, describing plaintiff's counsel, that's Buzbee, as self-promoting and accusing him of extortion. Docket number 41, requesting to be heard on an expedited basis and accusing Buzbee of exploiting the legal process to generate media attention. She cites to document 42, where Spiro asserts that Buzbee, quote, seeks only to benefit himself. She cites to docket number 46, requesting the shortening of a deadline from 21 days to 1 day. She cites to docket number 48, where Alex Spiro describes Tony Buzbee as willing to, quote, blatantly violate the core ethical obligations of all attorneys, and requested a hearing on the following day. The judge said, Carter's lawyers, that's Alex Spiro, quote, relentless filing of combative motions containing inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. The court will not fast track the judicial process merely because Alex Spiro demands it. Although Alex Spiro assails, that's like Buzbee as having a, quote, chronic inability to follow the rules, which is at docket 48. It's actually, the judge says, Carter's counsel, Alex Spiro, who has, quote, failed to abide by this court's clear rules. So Alex Spiro out here blaming Buzbee of having a chronic inability to follow rules. He's chronically unable to follow the rules, Your Honor. The judge said, well, look like you the one chronically unable to follow rules, Alex, because look at you failing to follow the rules in my court right here. Under the court's individual practices in civil cases, and with limited exceptions, quote, a pre-motion letter is required prior to filing any motion. So before Alex was putting forward all these motions, he was supposed to file pre-motion letters because this is civil court and there's a rule here that you got to do that. He was supposed to ask the judge for permission before he filed any motions. And the judge is like, you filed all kinds of motions without asking my permission. You're supposed to ask before every one. And you talking about somebody else can't follow a rule. Although Jay-Z's attorney stated that he, quote, this is Spiro, that he, quote, intended to file immediately a motion to strike the First Amendment complaint under Rule 12F, and she cites to docket 46 at paragraph 3, Alex did not, quote, give plaintiff, that's Jane Doe and Buzbee, the requisite 5 business days to respond. Okay, so not only did Alex Spiro fail to follow the court's explicit rule to file pre-motion letters, getting permission to file these motions in the first place, he broke the rules in another way by not giving Jane Doe and Buzbee the required time to respond to these motions. Further, he broke more rules, the judge is saying, because he did not, quote, wait for the court to set a motion schedule. And also, he could have gotten out of this stuff by telling the court about some exception, which I do, to be fair to Alex and Jay-Z. I do think they did try to argue that this was exceptional, but the judge is kind of saying, you didn't convince me. I'm not convinced. Sorry. The judge said this, not only she's not convinced, right? She says explicitly, this is unacceptable. It's unacceptable. Now look at this little she denies the motion. The motion to strike, the motion to get rid of this complaint is denied, and it's done in the most unceremonious way possible, in my opinion. She does it in a footnote. I mean, a lot of people don't even read the footnotes. They forget to. But look, this is unacceptable. Footnote 2. She don't even put the denial in the body. She says, on the merits, Jay-Z's motion to strike to get rid of the complaint, denied. Motions to strike are generally disfavored and only are going to be granted if there's strong reason to do so. Jay-Z's motion, which just concludes that plaintiff's claims are baseless and salacious, does not. Anybody can come to my court and say it's baseless accusation. No, denied. It's in a footnote. Woo! Okay. Now here's the little admonishment. In my opinion, looks like admonishment. In my opinion, looks like a warning. The judge says, counsel, Alex Spiro, counsel, is hereby advised that any further motions filed in violation of the court's individual practices may be denied on that ground alone. So because she put this part down here in the footnote, I don't know what exactly, quote, that ground alone. Like, is she referring to this ground down here, which is the Abdu Walker case citation, or is the, quote, that ground alone the fact that he did not give plaintiff the requisite business days to respond or wait for the court to set a motion schedule or state whether any exception to the court's individual practices applied? I'm not exactly sure what grounds she's talking about, but it's one of those ones either in the footnote or the ones that we just read, all of which I believe are going to be difficult for Alex to do. So the judge is basically putting a stop on it. She said, I'm not about to be rushed over you. Okay. Calm down. I have other stuff to do. We definitely have rules in place, which Alex Spiro should know because he is, like I said, highly qualified, highly competent attorney who works at a very prestigious law firm. So the judge is like, look, Alex, I ain't trying to embarrass you out here, but if you keep filing stuff like this, I'm going to just deny him without even requiring anybody to respond to him, because you got to give people time to respond to stuff. You can't be rushing me. And we're not just going to be saying, oh, it's not true, and then cases get dismissed. Okay. We got to go through the processes here. That's, in my opinion, based on what I'm reading right here, that's kind of what I would translate the judge to be saying. If y'all have a different translation, a different understanding, that's, possible. I'm just reading it just like you are from the public docket. The judge says, lastly, although Alex Spiro is entitled to file a Rule 11 motion, this is for sanctions, without first seeking leave of the court discourages this approach. Hint, hint, Alex, is what the court's saying. Yeah, you're entitled to do it. You're entitled, Alex, but don't expect me to like it, and don't expect me to encourage it or be happy about it, and don't expect it to help your client. If Alex Spiro still wants to serve Buzbee with a motion for sanctions, this court denies his request to shorten the safe harbor provision from 21 days to 1 day. Okay, so this has kind of already been denied by default, because the 1 day that Alex Spiro wanted to have Buzbee reply to this motion for sanctions already came and went. It's come and gone, and the judge didn't grant it. So the judge is saying, I don't really think Alex Spiro should file any Rule 11 motions without first seeking leave of the court to do so. The judge says, but I guess Spiro has the right to do that. However, if he goes ahead and does that, even though I'm telling him I discourage him from doing that without seeking leave, if he does do that, I ain't giving him no shortening of the safe harbor provision, because it's not fair. I mean, probably other things, but the reason that the safe harbor provision exists at all is because, as we can see, at any time, people can make any type of allegation against you as a lawyer. Sometimes true, sometimes not. If any and every person could just file these complaints against somebody's lawyer on the other side, you can imagine how, especially cases like this where there's a lot of money and a lot of trickery afoot, in my opinion, we could get all caught up in the weeds about lawyers instead of talking about the merits of the case. So judges really are not that gung-ho about giving sanctions out to lawyers. They want to be able to focus on the merits of the actual case. They don't really want to get all in the side weeds about lawyers. They generally give a lot of latitude to lawyers to kind of represent their cases how they want within the rules. The judge said, I'm not going to take away Tony Buzbee's 21-day period to respond to these allegations. There's really no reason to do that. The judge says Carter's motion to strike the amended complaint under Rule 12F is denied. We're not striking no complaints. By January 10th, Jane Doe and Buzbee have to file their response to Jay-Z's motion for an order directing the preservation of evidence. By January 17th, a week later, Carter shall file his reply if Any. Okay. So we've dealt with a lot of things here. There's a bunch of motions on calendar. The judge has kind of disposed of some of them, and then some of them are still alive and well. The Jane Doe thing, for now, has been decided. For now, Jane Doe can move forward as Jane Doe. The judge says that the balance factors will certainly shift as the litigation proceeds, specifically whenever they get to discovery in earnest. She denied the request to take away Buzbee's 21 days to respond to the sanctions motion, which I'm not sure the sanctions motion has even actually been filed yet. Again, the judge is discouraging the filing of a sanctions motion against Buzbee without first seeking leave of the court. She's not letting them have, a shortened time period, and they are going to be discussing in the next few weeks the preservation of evidence thing. Now, I hope that Emily D. Baker makes a video about this specific issue, because I thought that that was just like a stipulated understanding that you preserve evidence whenever there's litigation. So I thought it was just a given that you have to preserve evidence. I really don't know. I hope that Emily D. Baker weighs in on this, or somebody with a little bit more knowledge of the specifics of federal procedure as to like, what is this motion for an order directing the preservation of evidence, and how is it different from something that would just happen as a run-of-the-mill thing in a trial? I really do not know. Okay, but yeah, so the judge, in my opinion, just went right off. She just went right off. And in my opinion, reasonably. Alex Spiro did come out aggressive for Jay-Z. He came out real aggressive. In 17 days, he filed all kinds of stuff. The judge did even list it in that box, right? What did he filed? At least 38, 41. So document 38, document 41, document 42, document 46, document 48. It's a lot of stuff. And the judge is like, look, listen, if you keep doing all this, filing all these motions without asking my permission first, I might just deny them right out the gate. So calm down, chill out, relax. We're going to definitely have the case moving forward. Motion to strike is denied on the merits. Motion to make her say her name is denied for now. Motion to shorten the time limit for Buzbee to respond to these horrendous allegations to 1 day, denied. Especially, she didn't say this, but I'm just thinking, in light of the fact that Buzbee's now having to respond to all kinds of like allegations against his own self. It's very crazy. It's very, very crazy, very interesting to me. That's all I really had for right now. There have been some more documents filed in the Diddy criminal case. I will be discussing those as well. The filming for this video today, this recording session has taken way long. I thought this was going to be like a 20-minute video. We're over an hour right now. So maybe I'll get to the Diddy criminal case updates today. Make sure that you are subscribed and your notifications are turned on, because I will be covering the Diddy criminal case next, probably. I also have some updates about the Luigi Mangione trial in the state court and a little bit of information about that. Mark Agnifilo, it's common knowledge now that Mark Agnifalo's wife, Karen, is representing Luigi Mangione. But I think it's less common knowledge that Mark Agnifilo is also Luigi Mangione's lawyer. He is also representing him. It's just he's not the lead lawyer on the case. So I thought that was interesting. We'll talk a little bit about that and what went on at the arraignment hearing where Luigi pled, and how there might be some tug of war going on behind the scenes between where to keep Luigi in custody, whether he should continue to be held at the federal detention center where Diddy is right now, and Sam Bankman-Fried and a bunch of other people, or whether, because Luigi is having his state trial heard first, whether he should be in state custody. So we'll talk about that a little bit, and there's just some other stuff going on. It's going to take me a bit to get caught back up, but I am feet to the ground. We're going, girl. So make sure your notifications are on. That's all I really had for today. In the meantime, facts ain't defamation, and neither are opinions, and neither is reading from a public court document. Chill out. Love you, mean to get bye.